Court rejects MetLife's attempt to discredit a disabled woman and her doctor. When you file a disability claim, you can expect that the disability insurance company or plan is going to evaluate your case fairly. But what happens if they accuse you of manipulating your doctor just because you've consistently reported the same symptoms over time? Now, that's exactly what happened in a recent case involving MetLife, and the court didn't buy it. This is the case of Dime versus Metropolitan Life. Ms. Dime had a documented history of serious abdominal and pelvic issues, for which she underwent surgery to remove an ovarian cyst, but she continued to suffer from intense pelvic and groin pain. That pain made it nearly impossible for her to sit for extended periods of time, something she needed to do in her sedentary job. Now, she applied for her disability benefits through her employer, and the plan was administered by MetLife. Instead of evaluating this medical evidence objectively, MetLife denied her claim. And one of the reasons they raised, without proof, is that somehow Ms. Dime had manipulated her doctor or influenced her doctor into writing specific medical statements to support her disability claim. Now, that's a bit bogus. And fortunately, the court saw through it. It called MetLife's theory speculative and unfounded. The judge noted that Ms. Dime's treating physician had observed her symptoms repeatedly and documented them using similar language over time, not because of any conspiracy, but because that was actually what was happening. And the court added that reusing consistent language isn't unusual in medical records. In fact, it's a normal part of how doctors are documenting ongoing conditions. The court emphasized that the medical records are created to help healthcare professionals communicate and keep track of a patient's treatment. They're not to serve as legal evidence, and not legal evidence in an ERISA disability claim. That means that if a doctor describes your condition the same way at multiple visits, it's not a red flag, it's good record keeping. That said, there are still ways to make sure your record supports your claim in the strongest possible way. At every visit, you should be giving your doctor a clear and honest update on your symptoms. So if sitting is difficult, describe how long you can sit at one time, what kind of breaks you need, how long those breaks are, what you do during the break to relieve pain, ice, take medication. Let your doctor know that the nature of those symptoms and how it impacts your functionality. And you also want to talk about how your symptoms worsen over the course of the day and explain how they might impact your ability to do your job. Can you focus? Can you sit through meetings? Can you make it through a full workday without having to lie down or change positions? So be specific and give real-life examples. Make sure your medical records are documenting your symptoms and functionality, because that will become powerful evidence in your claim. And what this case shows is that disability carriers and plans will go to great lengths to deny a valid claim, even making baseless accusations against both patients and their doctors. But the courts are watching, and they don't appreciate these unfounded conspiracy theories. If you're dealing with chronic pain, post-surgical complications, or any other condition that's impacting your ability to work, you have the right to a fair evaluation of your claim by the ERISA disability policy or plan. If that's not happening, call us at 727-894-3188 for a complimentary consultation. We can help you regardless of your medical condition, regardless of who that disability carrier might be, and regardless of where you live in the United States. 727-894-3188.